of the Constitution of Jamaica. Lastly, the fact that the prosecution was prepared to waive the irregularities in the trial did not absolve the trial judge of his responsibility to ensure a fair trial. In all the circumstances, the trial judge ought to have discharged the jury and ended the trial in order to protect the integrity of the system of trial by jury. Against this background, the court has to determine whether the interests of justice require that the appellants be ordered to face a new trial, or whether judgments and verdicts of acquittal should be entered. The court starts with the Constitution, which provides that upon conviction, a person should not be tried for a second time unless a court of superior jurisdiction, which is the appellate court, orders that there be a retrial. The Constitution did not set out the circumstances in which the court should order a retrial. It is to case law that the court looks to determine what are the principles applicable to the question of whether there should be a retrial. The court looked at all the applicable legal principles governing the question of a new trial, which was set out most authoritatively by the Privy Council in the case of Reed against the Queen. We will not state the citation at this time, but that is in writing. The court also looks at other principles emanating from subsequent cases since Reed, and we have an amalgamated list of those factors. There are 12 factors that the court has considered. The seriousness and prevalence of the offense, that's one. 2, the strength of the prosecution's case. 3, the availability of the prosecution's witnesses and exhibits. 4, the availability of the defense witnesses. 5, delay and whether a retrial can be facilitated within a reasonable time. 6, the time, financial costs, expense, and impact on the court's resources of a new trial if one is ordered. 7, the ordeal to be faced by the appellants if a new trial is ordered. 8, the impact of prejudicial publicity on the fairness of a new trial, if ordered. 9, whether the new trial would give the prosecution an unfair advantage. 10, changes in the Jury Act. 11, potential legislative changes in the sentence for murder. 12, the possibility of prejudice arising from the mandatory minimum sentence and minimum term before eligibility for parole. We have considered all the factors governing the court's determination of whether a new trial should be ordered, and have given due regard to all the material, submissions, and evidence presented by the appellants and the Crown. We commence by stating that the egregious nature and seriousness of the offense in this case is beyond argument. So too is the prevalence of the offense of murder in Jamaica. We make bold to say that the features of this case bear every hallmark of a deliberate attack on and barefaced defiance of law and order, involving allegations of transactions relating to illegal firearms, a killing in respect of which the body of the deceased has not been recovered, or should we say an alleged killing in which the body of the deceased has not been recovered, and interference with a crime scene while it was under the control of the police. The court is therefore satisfied that the nature, seriousness, and prevalence of the alleged offense in this case are powerful factors that weigh in favor of a retrial. The court, however, finds that there are several equally powerful factors which, when combined, militate against ordering a new trial. In summary, these factors are the insufficient and inadequate account by the prosecution for the availability of its witnesses and trial exhibits. Witnesses and trial exhibits relied upon by the appellants, which tended to support their defense at their first trial, are now unavailable or cannot be accounted for. 3. The appellant's trial in the Supreme Court was complex, lasting 64 days, and utilized a significant share of the court and the appellant's resources. Therefore, the time, financial costs, expense, and impact on the court's resources, as well as other cases in the queue awaiting trial, we find that this is significant and it militates against a new trial. 4, the psychological, financial, and medical effect that a new trial would likely have on the appellants who have already spent 13 years in custody, which is demonstrated by medical and other affidavit evidence. We look at the medical problems relating to the appellant Palmer, which came through medical reports that stand unchallenged by the Crown and therefore speak to declining health in the penal institution. The court looks at the lapse of time between the commission of the alleged offense and the likely time in which a new trial would take place, which would, in our estimation, be at least 15 years. We find that to be inordinate. 6, the unjustifiable interference with the appellant's constitutional rights to a fair hearing within a reasonable time under Section 16 of the Constitution of Jamaica, and the potential for that breach or interference, we should say, continuing if a new trial is ordered. We look at the potential prejudice to at least 2 of the appellants who, if convicted after a new trial, would be required to serve a longer term of imprisonment before eligibility for parole than that which was originally imposed upon them after their first trial, due to the operation of the statutory mandatory minimum for the offense of murder. The court looks at other factors which it did not see swinging the pendulum either way, and our judgment will explain it all. We find that the submissions regarding pretrial publicity did not assist the appellants. We find that pretrial publicity is such that you would have to prove that it is impossible to obtain a fair trial. And that question is one for the trial court. What the court did find coming out of the issue of pretrial publicity is, if the mechanisms have to be employed as the Crown had argued, that would add to the delay of the proceedings. As we have said, we have looked at all the other factors, but we find by now, having weighed everything in the balance, that the countervailing, the weight is against a new trial. Our judgment will explain everything in depth, but as we say, this is for the decision, for you to understand what the court has done. Having regard to all the considerations the court has taken into account, we conclude that the interests of justice do not require a new trial to be ordered for the appellants, and we therefore make the following order. Judgments and verdicts of acquittal are entered in relation to the appellants. We must, on the record, thank our judicial clerks